5, 4, 3, 2.
This is a lecture about revocation of a will by operation of law. Now, there are 4 circumstances under which this occurs. One is the omitted spouse case. The other is the omitted child case. The third one is where the testator did not know the child was born. And number 4 is the case where there has been a dissolution, and under 6122, Probate Code Section 6122, upon dissolution, anything that the will gives to the former spouse is revoked. Any powers of appointment, any appointing that person as executor, giving them property, none of that stuff, all that's revoked upon dissolution. And by the way, if those same 2 people get married again and the will hasn't been changed, all that stuff is reinstated, interestingly enough. Now, so looking at revocation by operation of law, one more very important thing you need to know here is that revocation by operation of law is the way that the family protection statutes are carried out. It used to be in the old days, after 1540 when the statute was written, that if a person, first of all, if a woman got married, her will was revoked entirely. If a man got married and had a child, an heir, then his will was completely revoked. And this went on for years, where if your circumstances changed, the will got revoked. And then we gradually began to change that, saying, well, look, there's no reason to revoke the entire will just because the person got married. Let's just revoke enough of it so that the new kid gets the share that he or she was entitled to. And in the case of a spouse, that just to revoke enough of will, take care of the spouse and don't mess up everybody else. And so that's the way the rule is nowadays, but you can see why that comes under the heading of revocation by operation of law, because that's the way it started out, and what we have now is kind of a variation on that. So the family protection statutes and these revocations by operation of law are exactly the same thing. First, revocation by operation of law when there is an omitted spouse. That is to say, if the marriage occurred after the will was written, then the will is revoked to the extent of giving that person their intestate share. And there's some qualifiers now, and I'm going to give you the qualifiers in just a minute. But the basic rule at 21.610 is that this is what happens. Now, this used to be, the old rule that carried this out was at Section 6560, Probate Code. And what 6560 said was that, exactly what we have on the board here, that if the person got married after the will was executed, then it was revoked to the extent necessary to give the surviving spouse. But 6560 actually used the word will, that the will is revoked if this happens. But a lot of people are disposing of their property by living trust nowadays. You know, various revocable trusts, which are living trust, and it's so much simpler. You don't have to do all the probate stuff. And so in 1998, the law was changed to replace the word will with testamentary instrument, and that included revocable trust, revocable trust. And so the way the law is now is in red, revocable trust. The way it was in 1998 is here. This is the old number, this is the new number. If the child was born or adopted after the will, that's an omitted child, or after a testamentary instrument beginning in 1998, which included wills and revocable trust. That's found at 2120. If the person did not know that they had a child, that child gets an intestate share under 21.622. Okay, so we know how to become an omitted spouse, how to become an omitted child, and we know that the basic policy is to give that person their intestate share for both the spouse and the child. But there are some qualifiers. And let me show you what the qualifiers are, because every time this has been tested, they've tested the qualifiers. Okay, they don't want just a basic rule. Now, if you look here at this section, dealing first with the omitted child, it says the omitted child gets an intestate share. And that's what we've been talking about, and that's found at 21-620 of the probate code. But the omitted child gets the intestate share unless some of this happens. And this is where the test always is. One, if the omission was intentional and that intent shows on the face of the will or testamentary instrument since 1998. So you'll be tested on this one. So if the bar examiners test this, they're almost sure to give you a living or revocable trust rather than the will to test to see if you know the current law. The second unless here is unless, and this is the one that gets tested a lot, unless there are other transfers that were made by the testator in lieu of a devise. So you got this, so you have this newborn child, and the testator says, look, newborn child, I'm not going to change my will for you, but I tell you what, I own Blackacre, I'm going to give you Blackacre right now. Okay? Or I'm going to put Blackacre in trust and make you the beneficiary of trust. And the Blackacre that you're giving this newborn child is roughly what you would have given, the other kids. And so it's the person either says or it's apparent that you're giving the newborn child a Blackacre in place of changing the will. Well, you don't give the kid a forced share also if that happens. And so that's what this is about. Other transfers in lieu of the devise. And these other transfers historically have been either a gift or a trust set up for the kid. And how do you prove that the transfer was in lieu of the person taken from the will? The statute says you can use words that the person used before or after. It doesn't matter when the words were spoken. Or the amount of the transfer can be used, or any other evidence you can get that it was in lieu of can be used. And finally, in the case of the omitted child, and this one gets tested also. 2 and 3 are the ones that have been tested the most. If the decedent left one or more children and left substantially all of the estate to the other parent, then you don't want to give the kid an enforced share in that case. For example, there was a real test question where the bar examiners, the person in a will, they gave you a whole lot of stuff that the person gave away in the will, and the spouse got the residue. Well, of all the stuff that's given away, when you added it up, that represented about 20% of the estate. So the surviving spouse got 80% of the estate. But you had to sort of go through a little math to see that. And the surviving spouse got 80% of the estate, but a child had been born after the will was written. So that child should get an intestate share of this. It was separate property, by the way, because the intestate share of if it's community property, the surviving spouse gets everything if you don't have a will. So the intestate share, you have to worry about children for community property. But for separate property, the children have an intestate right. And so this child that was born and the person who died had some separate property, but he left 80% of this separate property to a surviving spouse and then had a newborn child. So you can see how this was being tested right here. The decedent had one or more children and left substantially all. You had to argue that 80% is substantially all of the estate to the other spouse, obviously to take care of the children. That takes care of the omitted child, and this brings us to the omitted spouse, which is on the next board over here. In the case of the omitted spouse, the rule, you know who omitted spouse is, and the rule is at 21-610. Now the old rule here before 1998 was at section 65, this is 6560. The other one I told you about, I said was at 6560, was really at 6570. Sorry about that, let me show you that. Let me correct that. For the omitted, no, this was correct, I'm sorry. Omitted spouse is 6560, and the omitted child, this one was 6570 here. Omitted child was here, omitted, but in 1998 they changed to these new ones. They included the testamentary instrument. Now, going back to the case of the omitted spouse, old rule 6560, a new rule. The main difference between the old rule and new rule is that the new rule includes testamentary instruments, not just wills, and that includes revocable trust. And what does the surviving spouse get if they're omitted? They get half the community property, but that's not gotten from the will. They already had that. They get half of the quasi-community property of the deceased, that is from the will, and they get their intestate share of the separate property, but never more than half. But they only get this, unless, and the unless is always going to be that either you didn't want the person to get anything or you've already provided for them. And number one here is just like the omitted child. Omitted intentionally, and that shows on the face of the will or testamentary instrument. So that says you didn't want the omitted spouse to get anything, and this is the one where you've already given them something. Other transfers that are intended to be in lieu of a device, and you can prove it was intended to be in lieu by words or amount of money or other circumstances. And finally, so this is the case where you said, I don't want my spouse to have anything. This is the case where you've already given them to him. And here's the case where the spouse has agreed by a valid agreement, waiving that person's rights in the estate. And people can agree to that if they want to. So if it's a valid agreement, this says, we agreed that my surviving spouse doesn't get anything. Up here, you don't want to give them anything, and here you've already given it to them. And that's what this code section is about. Let me give you a couple of hypos to see how this got tested. Here are some hypos from real bar questions from the February 2007 bar exam. It says, I'm not going to read the whole question, just the part that relates to what we're talking about here. It says, in 2001, Tom was a resident of California, executed a valid will. Okay, skipping all the other stuff. It says, in 2003, Tom and Wynn had a child. Okay, next part. In 2005, Tom died. Okay, you got your omitted child. From the July 2001 California bar exam. It says, Ted received a letter from a woman that he had had an affair with who said that the child she had was Ted's son. And it says here that until then, Ted was unaware of son's existence. But Ted says, I don't believe it's my kid. Okay. Then Ted died, and then the fact said after Ted's death, DNA testing confirmed that it was Sam's kid. So there you have it. This is the case where the person did not know. Let me move this board over here. This is this case where the person did not know the child was born until, and so died without knowing the child was his or hers. Hard for a woman not to know that, so it's usually guys. Final example from the July 2000 California bar exam. In 1996, Hal married Wanda, created a trust. 1998, 2 years later, Wanda executed a will, and shortly thereafter, Wanda died while giving birth to the couple's second child. Now, if she died while giving birth to the second child, she obviously didn't include the second child in the will, and there is your omitted child. So that's how these revocations work. There are 4 ways to do it. The omitted spouse gets there's revocation by operation of law, partial revocation. Omitted child, person didn't know the child was born, and number 4, upon dissolution. And in each case, what you do basically is you try to give the person, you say first, maybe you left them out intentionally. If you left them out intentionally, they're not going to get anything. Secondly, if you didn't leave them out intentionally, we're going to give them they either give them their intestate share, basically. And finally, there's the final case where you've already agreed, in the case of the spouse, the surviving spouse, you've already agreed that person is going to get anything. Or in the case where the testator leaves substantially all of the property to the surviving spouse, obviously to take care of the children, so the afterborn child doesn't get an intestate share. That's the end of this lecture and hypotheticals.